Salutations to all our future judges. In this video, we are going to see Indian Evidence Act 1872. But before going into the video, I'd like to make few requests to our viewers as well as the subscribers. Kindly do not skip the video. Watch the video from the beginning till the end. If you skip in between, you may be missing very crucial information or very crucial aspects which have been explained. Hence, watch from the beginning till the end. And next request is, please do have a notebook and a pen with you, because various questions which have been asked in Evidence Act in various exams would be mentioned or would be stated. And in addition to this, idea would be given as to how questions could be framed in a particular section. It is very important for you. So you all need to make a note of all these aspects. And in addition to this, some additional illustrations would also be given while teaching the act. Hence, you please make a note of all those additional illustrations as well. They would be of absolute help to you in understanding the particular section. And in addition to this, various ways or techniques would be taught which would help you to remember those sections, or to say some memory techniques would be given. This would be really helpful to you in remembering the sections when you go to the exam. I hope this video would be of absolute and great utility to you. Section 144. Evidence as to matters in writing. Now, let us try to imagine this particular situation or try to picturize this particular situation. A person is giving a property by way of contract or grant or other means of disposition of the property, and that is mentioned in a particular document. So a witness is coming to the court to give evidence in this regard. Now the question is posed to that particular witness whether the particular contract, grant or other disposition was contained in the document. He says yes. Or if that particular person is going to make some statement about the contents of a document, and that particular document is in the opinion of the court to be produced before the court. So in that case, the adverse party may object to such evidence being given until that document is produced or until the facts have been proved, which entitle the party who called the witness to give secondary evidence of it. Let us try to understand the explanation what has been given. A witness is there. Now he comes to know that another person has given a statement which is very relevant to the case. In that case, this witness can give oral evidence about the statements of that particular person. Let us see the illustration what has been provided. The question is whether A assaulted B. That is the question. So a third party C comes to the court and says that I heard A saying to D that B wrote a letter accusing this particular A of theft, and he says I will be revenged on him. So this statement is very relevant because it shows the motive of A. Now imagine there is a house. B goes into this house and steals a ring and a chain. He gives these properties to A. A denies that he is in possession of the property. Now the court can do this. Court can say, first identify this property. Identify the said property and go for denial. That is, this one can be first, this one can be second, or else this one can be second, this one can be first. That is, the court can say first identify the properties, then let us go for denial. Or the court can say first let us go for denial, then let us identify the property. It simply says that court can decide the order in which it needs to be done. Section 145. Cross-examination as to previous statements in writing. There are two situations where a person is standing as a witness. In that case, you show to him what he has given in writing, then ask certain questions. In some cases, you don't show this to him. Without showing what he has written, you can ask questions. There are two situations. Now let us see how these two situations work in this particular section. So, this particular witness is now standing in the box for cross-examination. He has given a previous statement which was reduced into writing or he gave in writing. And the aspects of the statements are very relevant to the matters in question. Then you need not show that writing to him if you are not going to contradict him by the writing what he did. For example, I am writing something and you are going to cross-examine me. So, if you are not going to contradict what I have written, then you need not show the document what I wrote. If you are going to contradict what I wrote, then in that case, you need to show what I have written. You need to seek my attention towards what is being written. That is what is explained in section 145. Now, let us move to section 146. Questions lawful in cross-examinations. In addition to what has been stated earlier, certain questions can be asked which generally test the veracity or the truthfulness of the witness, or questions which discover who he is and what is his position in life. These things can very well be done. Or questions can be asked to shake his credit by injuring his character. Though this answer, what he gives to this particular question which shakes his credit, might expose him directly or indirectly to a penalty or forfeiture, still these questions can be asked. However, there are some exceptions, particular with respect to offences against women, and particularly those offences which are covered under 376 and its subclauses A, AB, B, C, D, 376 DA, DB, and 376E, and so on all these sections. So, under all these sections, if that particular lady who is the victim is questioned, in that case, questions cannot be asked with respect to the general immoral character of that lady or her previous sexual experience to prove that she gave the consent or the quality of consent is an acceptable quality. In all these situations, such cross-examination or such questions cannot be asked. That is what is given in section 146. Now, let us move to section 147. When a witness can be compelled to answer. If the questions are relating to a matter relevant to a suit or proceeding. If I am raising a question to a witness with respect to any other suit or proceeding, in that case, the provisions of section 132 will apply. Already we have covered section 132. If you have not seen that, I am providing the link of that particular video in the iCard. Please go and watch that particular video. Then you will understand what section 132 speaks about. Then you can correlate what has been stated there with this particular section 147. I hope you would have liked the video. If you like the video, please do press the thumbs up button and do share the video with your friends and motivate them. If you are not subscribed the channel, please do subscribe the channel and share the channel with your friends. If you feel that I've left something in this video or you want me to change the way in explanations are given for the sections, please do let me know by way of comments. Let us join hands together and contribute for a learned society. Thank you.